Welcome to Legalized Negligence, where we are talking tonight about the potential repeal of Florida Statute 768.21 subsection 8. And we're going to pick up in the video from the meeting at the 28-minute mark where we ended last night. So let me go ahead and share that screen. And now I don't have the screen. There it is. All right, got it. Not going to let that interfere. Okay, so we're going to pick up here, and they just voted on Senator Book's amendment to the amendment, and it failed. And so now Senator Burton is going back to the original amendment to Senator Yarborough's bill. So we'll just pick up right here.
On the main amendment, which is barcode 932842 by Senator Yarborough. Are there any questions on the amendment? Senator Book, you're recognized.
We're not seeing the video.
And thank you, Mr. Chair. One of the questions that I have, and I know that the leader talked a little bit about threading a needle. And so I want to talk about why we think, or why putting these two issues together, wrongful death and caps, is the thing to do if you want to help families bring wrongful death claims, and why not have a standalone bill?
Senator Yarborough.
Sure. Thank you, Leader. Thank you, Madam Chair, and to the members of the committee. Again, what I articulated in the opening a few moments ago, and then what we just had a brief discussion on with regard to your amendment, we needed a path to bring stakeholders together. And we have those who've been engaged in this for quite a long time, those who've been personally impacted by 768.21.8, and then we have our business advocates and also our legal advocates that have been engaged as well. And as you mentioned, and thank you for your kind words, I give credit to the Lord for anything good we can do, but I'll say in trying to bring the balance together on this, it's been very difficult, but I am still open even after this stop today, regardless of how the vote goes and how our continued negotiations go. I've expressed to each of you on the committee when I've talked to you individually, and also to our stakeholders, this is the first stop. So if there are more changes to consider and another way we can thread this needle, let me put it on the record again. I am totally open to that. I just haven't been able to find another way to do this to give justice to these families who have been wronged by the law that's been there for 34 years and find a way to get that through. So that's why the two have been put together and what's before you today.
Additional questions? Senator Thompson, you're recognized.
Thank you, Madam Chair. Senator Yarborough, how does this impact the negligent individuals? Most of the physicians, most of the healthcare professionals are very competent, very good people. And so it's a subset of people generally that are engaged in lax safety standards. And by having these caps, are we shielding these bad actors who continue essentially to engage in negligent behavior?
I want to pause it there for a minute. I think Senator Thompson asked a very good question, but I want to go back to Yarborough for just a minute. I really don't like being called a stakeholder, but I see what he's saying, and the stakeholders are on one side. You have the insurance lobbies, the Florida Medical Association, the people who want to keep subsection 8 in place. And then on the other side, you have the families who want to do away with subsection 8 so that we can get back into the civil courts. Not that it's a big deal, but they call us stakeholders. And I just think that kind of devalues us a little bit. And as Senator Yarborough is continuing to show, he's open to new ideas, and that's what we're trying to do is to get some new ideas to him. And I appreciate that he is trying to find a way to do what the last 33 legislative bodies have not done. Now, Senator Thompson just asked a real important question, and this is like getting down to it. What are we expecting of the doctors? What are we expecting of the nurses? She recognizes that, if you're asking the people to give up something, and that would be in the form of caps, you're asking them to accept that you want to put caps on their damages. What are you going to do about the bad actors? the negligent doctors. And I think that goes to what we've been pointing out all along, is that according to the task force study and the law review article that we've cited so often, 4% of the doctors cause 42% of the malpractice payouts. And in fact, I heard a different stat just this past week that 2% of doctors cause 50% of the malpractice payouts, which is greater than what they had discovered in 1988 when the task force report came out. Travis, before I start that back and allow Senator Yarborough to answer, do you have any thoughts on any of that?
Yes, the answer to her question is really the result of us being allowed to get into civil court, because then the 3 strikes rule, for example, can come into play and deal with those bad actors. So that's really, at least in part, an answer to her question.
Okay.
That's not being allowed to happen.
All right. That's a good point. So let me go ahead and let's hear how Senator Yarborough answers her.
Senator Yarborough?
Thank you. Thank you for the question, Senator Thompson. I believe I understand the premise of your question. So I would not say that certainly the effort is not here, but I would say that there's nothing in here that would prevent our healthcare providers, our hospitals, any others who would be directly impacted from the practitioner or non-practitioner standpoint on this, from still maintaining high standards of care and making sure that those who are out there on the front line serving the individuals with need are operating with the highest standards of care. The first part of your question was how does it impact those who are affected by it? We would have the cap for non-economic damages, but again, just to make a distinction, we have no cap for economic damages. So anything related to medical bills, lost wages, and the like, those are not impacted by this, and that's not what I intend to propose at all. That's not on the table as far as I'm concerned. These are non-economic damages, which, as you and I spoke earlier today about it, it's a start point, and we can still fine-tune this and consider what the appropriate levels would be. I'm open to that, but I still believe there can be the high standard of care whenever the operation and the provision of healthcare takes place. The other thing, and it wasn't directly part of what you asked, but it's tied into it. Again, like the court ruled twice, 2014 and 2017, on the topic, and found that we needed to abide by equal protection with regard to how this is applied. And they took exception with that, with the 03 law put on the books by the legislature. This, again, is an effort to strike that balance and cure the 2 issues that they brought up with regard to equal protection. And if you have a single claimant, they could get $500,000, but under the prior iteration of the law, if you had 4 or 5 claimants, they were all subject to that aggregate cap. This moves to per claimant caps, so each of them have the opportunity to get up to that cap amount individually instead of in the aggregate.
Okay, basically he's saying 4 things here. He's given her 4 answers. One is that this bill and its amendment will not affect the good actors, the good doctors, the ones who are not, committing malpractice. The second thing he says is that it's a good starting point, and that he's open to making some adjustments in it as it moves through the other committees, and eventually, if it ever gets heard on the floor of the Senate. The other thing that he's said is he brought up the issue of equal protection, and I simply haven't had time today to go back and look at the Gallatin holding or the McCall holding to see what the court said there, but he seems convinced that the issue about equal protection was aggregate versus per claimant. What he doesn't say here, and I think that this says a lot, what he doesn't say here is any stiffer penalties towards those who commit medical malpractice. He doesn't bring that up at all. And that's been our issue all along, is they only seem to want to be asking the people to give up something. And when they talk about this striking a balance, they don't want to talk about stiffer penalties. They don't want to talk about investigations. They don't want to talk about revamping the Department of Health and ACA. They only want us to give up something, and that something is in the form of caps. Do you have any comments, Travis?
Yeah, I noticed how he sidestepped her answer. She was looking for, what are you going to do about the bad actors? And
Exactly.
he said, well, there's nothing that prevents people from still doing good medicine. I'm like, hold it, that's not the answer or the question. Yeah, he just totally sidestepped it.
Yeah, and none of them ever want, they want to admit that malpractice occurs, but they never want to take any steps to do anything about that. And that would be so easy to do. That would be so easy for either Department of Health or ACA to deal with, or for the legislature to write some law that deals with that, but they never want to go into that. At some point you got to start asking yourself, why do they insist on protecting these doctors who they willingly admit, from last night's podcast that we did, that hundreds and even thousands of malpractice incidents are taking place every year in the state of Florida? Why doesn't anybody want to talk about that? Now they're going to move. If you didn't have anything else, Travis,
we're good.
Okay, they're
Let's move
going
on.
they're going to move to Senator Stewart. We'll see what he has to say.
Thank you.
Additional questions? Okay, seeing no, oh, I'm sorry, Senator Stewart, you recognize?
Now, I'm just trying to decide if I do the questions now or wait until the bill itself is.
There's a second opportunity. Yes, ma'am.
All right, I'll wait.
Thank you.
Sorry, I didn't mean to call Senator Stewart a he. I didn't really. I can't see her, so I didn't know that it was a she. So she's gonna reserve her questions until they get off of the amendment and get back on the original bill. Now they're going to move to public response, and I'm going to tell you what I'm going to do. I'm going to take this down for just a minute because I need to fast forward through some of this, because there's some stuff where people wave in support or wave in opposition to. So Travis, if you don't mind just maybe sharing some thoughts on something while I move this to the point that we need to be, I would appreciate it.
Okay. I think that we all should submit to Yarborough ideas for where we want the bill to go in what direction, because he opened up saying that if there is another way to thread the needle, I am totally open to that. That is him calling out to each and every one of us to provide a response. So if we're complaining about the way the law is and we don't respond to his request for a response, for ideas, then that's on us. That's his call to action.
Yeah, I agree with you. In fact, I made a note here, and let me see if I can find this. I made this note to myself. It said, make a point about limited time to speak and how you should have been speaking all year long. The lobbyists have these people's ear all year long. They have their phone numbers. They can see them in the halls of the legislature. They can talk to them. And it seems like the people think that the only time they have an opportunity to speak is in the 1, 2, or 3 minutes that they're given at either delegation meetings or these committee meetings, when really they can be speaking all year long. And you can't blame the legislators. I mean, they're open. We can get their email addresses. We can get their phone numbers. We can get their snail mail addresses and send them letters. It's up to us to speak to them. And if we're not going to speak to them, then we can't blame the lobbyists who have taken advantage of their time and shared their points of view. And I think that goes along with what you just said.
Exactly.
Okay, well, we're going to start now. And I believe, let me see, I lost my spot here, but I believe we're up to one of the people who opposed the bill who was going to speak, and this is Paul Reinhardt's brother. Let's see if my video starts. Why I'm having so much trouble with this tonight.
Big brother found you.
Yeah, I think so. I mean, you can see the screen, right?
Yes.
Okay. I have no idea why this isn't starting.
Shift the slider, just hit the 10-second button back and then hit it forward to force it to key.
Okay, here he is. I have no idea why this is causing me problem tonight. It worked fine last night.
Hit your space bar. Hit it again.
Don't know. I'll tell you what, if you can bear with me a second, I'll reopen this. Let me try to do that. I'm going to stop that share and then close my media player and go back and reopen it. I'm sorry about this, but technical problems.
Are you streaming it off the internet or is
No, I'm playing this off of my computer.
Right.
I did that so that we could get a better.
Okay, members, we will go ahead and reconvene. At this time, I will pass the chair to Vice Chair Burden.
Let me get it to where I think I was. All right, I've got it reopened. Let me share the screen again. Tell me when it pops up, Travis.
All right, it's done.
Okay, we're back to George Reinhardt, and let's hear what he has to say. I gotta.
The waiting area back. Dr. Reinhardt, you recognized?
Yes, Chairman Yarborough, I thank you for your work and also Senator Book for your work. What I was, I'm a potential free kill. I meet all the requirements for that. There are good doctors within the state of Florida. I had colon cancer 2018, fully recovered. But the thing is that 49 of the states, they don't have the free kill law. And what it was required when you have a medical malpractice suit, you had to get a chief expert witness, another doctor, to testify that there's a prima facie case. And that's sufficient for 49 states. And we should eliminate the caps because somebody that's paraplegic or a quadriplegic, $500,000 when they're this ex-actor Superman, Christopher Reeve, he was quadriplegic, and his care is more than $500,000. So there's no equity in this bill. And I agree with the amendment of Senator Book. And I thank you, Yarborough, for all your work. Thank you.
Thank you. Dr. Paul John, right?
Okay, I think Mr. Reinhardt is confusing economic and non-economic damages because, like they explained last night, that these caps don't really affect the money, the damages that you would get to pay for future medical expenses. But I think he does make a good point about the pre-suit requirements, and that's all we're asking. Get rid of subsection 8. There are pre-suit requirements already on the books. Let those weed out the frivolous suits and let us be treated like everybody else. We're not asking for anything special. We're just asking for the way everybody else is treated. Any comments, Travis?
it's hard to say what the future economic costs will be for medical care. When someone lives, 80, 90 years old, if they're injured right at 25, how in the world can they put a number on what that medical care is going to be today?
Yeah.
And it's arbitrary.
I wonder if that's a good point. I wonder if there would be a way, instead of a jury saying we're going to award X amount of dollars, could the jury not say all of his future medical bills that deal with this malpractice adverse event goes to this doctor or to this hospital? So he doesn't see any of those bills. So they just take care of that. And that way it's the exact,
Yeah, that's what I was thinking the other day, is like have a HSA card, where basically they need something for medical care. It goes on that specific card and the offender gets the bill.
yeah.
They don't
And
get to challenge it, to some degree, you don't want it to be abused. But yeah, I don't see why, because then look at the time value of money. They get to hold on to the money to invest it, whatever, until the need for the expense actually arises. And so that behooves the insurance company to hold on to the money and go for this plan. But they definitely have got to secure the availability of those funds for, a future expense, because you don't want them to go insolvent or whatever, and then the injured party, miss out.
yeah, and this way the jury's not having to guess. I mean, it's not like they have a crystal ball. They're not having to guess at what the future expenses are going to be. They're just going to say, okay, we found you negligent. All of his bills go to you. Period. It's over with. Was that all you wanted to add right there?
Yeah, that's good. Yep.
Paul Reinhardt, who you seem to know pretty well, is going to speak next. So I'm going to let you comment when he gets finished speaking.
Reinhardt will be followed by Dr. Charles Chase and then Carolyn Johnson. Dr. Reinhardt, you recognize?
The United States Supreme Court, as early as 1803, by the Chief Justice in Marbury versus Madison, said for every injury, there's to be a remedy. Like both my brother and myself are in this category. I had the honor of running for the State House of Representatives against Ralph Mazzullo, the poster child of the FMA. I ran against
sir.
him.
I'm going to ask you to please refrain from comments regarding any members of the legislature.
Okay. I ran as a Democrat. I ran as a Republican, and I ran on this free kill law, doing away with it. And the situation is that, there's a talk. Well, I entered this merry-go-round in 1990. We were talking about doctor shortages then. I attended medical school in Mexico, and I was treated by the Board of Medicine like dirt, while this legislature allowed Cuban and Nicaraguan exiles without documentation to get medical licenses, also in 1990. The solution is right in front of you. I am OPAGA. Well, I was up here when Lawton Child signed OPAGA. I was one of the first reports on how this legislature shouldn't have licensed certain doctors then. It was a great study to do, and that's the situation. I do not agree with the OPAGA study here. What we have is a situation where you want to re-examine this, re-examine that. Don't act on a bill until we have a proper OPAGA report. This problem has been going on since 1990. They did a great job on foreign medical graduates, OPAGA. Anna Estes was the first one in charge of it. We should have all the stakeholders and these families submit evidence to OPAGA.
Dr. Reinhold, I'm sorry, but could you just
Okay.
close right? This.
Okay, I actually feel that this needs to be out in the sunshine, and this should be studied. And I don't want these people leaving this time empty-handed. So somewhere along the way, get a real OPAGA report.
Thank you, Dr. Chase.
Paul should really tell us what he really thinks.
Yeah, well, he's absolutely right. You know, for every injury there is a remedy, and sadly, this law has prevented us from seeking the proper remedy in civil court. You know, without counsel, how are you going to go to court? You know, some of us will try to do it per se, but for the most part, this law prevents the remedy. And they'll say, yeah, sure, file a complaint with Department of Health. But what the law allows in the civil courts for recovery, the Department of Health has no say on it at all, because the Department of Health exclusively, their domain is of the license.
Yeah.
And not the person. And in civil court, it's the person, not the license. So, you know, that he's absolutely right about that saying. Regarding Opaga, he was part of the first study that did. That's why he mentioned that. And I agree, you know, why not learn from the past 32 years of this law? Why does Senator Yarborough want to delay it for 5 years to see what the effective caps are? You're missing a perfect educational experience of 32 years of data. You know, he makes a good point. We need to have the APAGA dealing with.
I lost your audio there, Travis. Something happened to your mic. I'm not hearing you. So yeah, now it's showing that you're muted. Yeah, you're still muted. I'm going to go ahead and while he's working that out, I'm going to go ahead and move to this next speaker, who is Dr. Chase. He is an anesthesiologist, and let's listen to what he has to say.
Followed by Carolyn Johnson, Eric Tinsman. You recognized?
Thank you, Madam Chairman. I'd also like to thank Senator Yarborough for what they call threading the needle for this issue. And thank you, fellow committee members. I'm an anesthesiologist. I'm a physician anesthesiologist representing the Florida Osteopathic Medical Association. I'm a past president of the Florida Society of Anesthesiologists. I'm on the board of both the Florida Osteopathic Medical Association and the Florida Medical Association. There is a malpractice crisis. No matter how you look at it, Florida is up at the top in almost every statistical category of malpractice. I've worked at Winnie Palmer Hospital in Orlando, and we're the second busiest OB hospital in the nation. I have personally cut back to working 25% of what I did previously, like many other physicians, because of malpractice insurance costs. Caps work. Prior to the installation of caps in the early 2000s, medical malpractice insurance for anesthesiologists in particular were going through the roof. Caps were installed. At that point, our medical malpractice insurance started coming down. When they were overturned by the Supreme Court in Florida, once again, our medical malpractice rates started going up. Mine are almost triple of what they were before the Supreme Court's decision. That was one of the reasons why I decided to go part-time. And many other physicians have done that because of the risk of malpractice. Thank God I've never been involved in a malpractice case in any form. So I want to speak for the many physicians that are out there doing a fine job. And I also would like to say that it bothers me a bit hearing a free kill, because I think that really is disrespectful to the quality of physicians in the state. In order to be able to recruit new physicians here, we need to be able to give a adequate, fair compensation to physicians that come to Florida. When malpractice rates are that high, it's very difficult to do so. Thank you very much for your time.
Thank you.
Oh boy, there's a lot there to unpack. Go ahead and talk for a second. Let me see if your audio's back.
Okay, can you hear me?
Yeah, I can hear you fine. Okay.
Okay, all right. Yeah, he points out he has an offense to the term free kill, and saying that it gives good physicians a bad name. Good physicians don't need to worry about that term. Everybody is missing the point. It is all about the bad physicians causing bad actions.
Yeah. I'm going to start at the top, because it's been proven that so much of what he said simply is not true. I mean, he starts off with talking about that caps work, but he doesn't say how they work. And in fact, Tom Baker has shown that caps do not work. And I'm going to get into that a little more after we get through this meeting, and then do a podcast on Tom Baker's book and show what he points out. Then he talks about the rates of anesthesiologists were going through the roof. Tom Baker points out that as the anesthesiologists in America are the only ones who got together as a group and said, what can we do to bring down our malpractice insurance rates? And they adopted a standard of practice that they all began to adhere to. And that's what brought their malpractice rates down. In fact, they're the lowest of any group of any type, any particular type of practice for a doctor. The anesthesiologists pay the lowest, and it's because they adopted a national standard of practice and all agreed to follow it. And when they did start following it, they started to see that their malpractice insurance premiums dropped. Now, it happened to coincide with these caps that he's talking about. But I'm going to, so we don't make this video go too long, I'll address that in a different podcast. But he is citing some bad data, and he's not giving the other part. He's leaving a lot out. He says that his rates personally tripled, but then he goes on and says that he's never been personally sued. Well, if that was happening to me, if let's say my auto insurance tripled, and I call my insurance company and I'd say, well, why did my rates triple? I haven't had an accident. I haven't had a speeding ticket. I haven't even had a parking ticket. Why did my rates go up? And their response would be, is because a lot of other drivers in your state, they're getting into more accidents and they're getting more speeding tickets. So we just raised everybody's rates. I mean, that would be the comparison that the average person could understand. So he's not being fair about that. And then I agree with you about the whole free kill thing. Here we go again with that. They're using that to discredit the people. And I did a video about why I got away from that term about a year ago. But I think it's interesting that he talks about, he thinks new recruited doctors to the state should get, and I don't quite understand what he means here, adequate, fair compensation for what? What is it that you want them to have adequate, fair compensation for just by moving to the state? It's like all you're interested in is the doctors moving to the state and not the quality of doctor moving to the state or getting rid of the bad doctors that are already in the state. So it makes no sense to me. If you didn't have anything else to say there, I'm going to go ahead and move on to the.
Well, I just find it that he says how bad malpractice is, and yet he's not owning it as like we need to do something to improve it.
Yeah.
He's just talking about the result of it and how it causes rates to go up. That's because it causes a lot of people injury and death. Mm-hmm. And he doesn't own that. He just wants the part that affects him to go away.
Yeah. And in that law review article that we've talked about before and that I sent to Senator Yarborough and Senator Book, it points out what I was saying a minute ago about the group of anesthesiologists who started their own, they adopted their own standards of care. And when they did that, they saw their own personal rates go down. So this guy is being disingenuous, Dr. Chase.
Carolyn Johnson,
5 minutes.
Followed by Eric Tinsman and Bobby Bowers will be joining us, please. Recognize. You just turned it off.
Did I? Okay, it's on. Thank you, Madam Chair, members of the committee. Carolyn Johnson with the Florida Chamber of Commerce. I want to thank Chair Yarborough for his thoughtfulness in trying to strike a balance with today's amendment. As our population continues to age and grow, and we're already at a shortage of medical professionals in this state. It's important that we take a look at improving our medical malpractice insurance market, and these caps do just that. We have the highest in the nation medical malpractice rates. You heard the doctor before me talk about him cutting back his own practice. And this amendment just helps address those concerns by following best practices in other states. Other states also have caps in place, like Florida did in 2003. Other states also got rid of or put in caps and saw significant progress in terms of attracting medical professionals, as well as lowering of insurance rates. And we believe that will do the same here. So we ask for your support. Thank you.
Boy, I have a lot to say here, but I'm going to limit it. People should keep in mind that Ms. Johnson works for the Chamber of Commerce, which is not a part of government. You won't find the Chamber of Commerce anywhere in the Constitution. The Chamber of Commerce is a nonprofit entity that started up, and they, my view of them is that they created a job in order to solicit donations from businesses to promote them, and that's how they get paid. So they kind of like created their own job. And if you believe in capitalism like I do, I don't guess that's a bad thing. But I wanted to point out, don't let me forget this, Travis, how the Chamber of Commerce threatened legislators a couple of years back if they voted in support of repealing subsection 8. So hold on to that thought while I address these things she said. The law passed, as we all know, in 1990, where they created and then punished a class of citizens, anybody over 25 and unmarried. And then 13 years later, they decided to install caps, which the Supreme Court, 11 years after that, ruled unconstitutional. So that made me start to think, wait a minute, you put a law in place in 1990 that was supposed to solve the problem with malpractice insurance being too high. 13 years go by, and then you decide to put caps in place. So did the law work? If you were trying something new by putting caps in place, why didn't you repeal the law then? So you punished the people in 1990, then you flogged them again in 2003, and then finally in 2014 and 2017, the Supreme Court stepped in and said, stop, that's unconstitutional. You can't do this to the people. And so keep that in mind. Now, Travis, remind me about what the Chamber of Commerce did a couple of years ago, where they sent a letter and they threatened legislators that if they supported the repeal of subsection 8, they were going to penalize them.
Yeah, apparently the chamber comes out with an annual review of representatives, and they said that we will dock you points if you vote this way. So, they're trying to extort, in my opinion, our representatives, the people's people that create laws for us, govern us. They were trying to force them into their way by establishing some arbitrary point system, and it got found out.
So you have a 501c3 nonprofit who is not part of any branch of the government, and they decide to threaten state legislators who were elected by the people. And they said, we're going to knock points off of your score if you support this law. Now, imagine if we called a legislator or sent them a letter and threatened them in any way, So if anybody, wants to write to the Chamber of Commerce, you can let them know. We really don't care much about what they think,
We're at time.
Yeah, exactly. Now, this next guy, Eric Tensman, I think that's how you pronounce his name. He has some very interesting stuff to say, and you're going to have to indulge me on him after he speaks, Travis, because I have something to share. But I'm going to let him speak. He is a trial lawyer. with the Florida Justice Association. And I'm going to say something here that might get me in trouble. But last week, Sabrina, the young lady who does podcasts with us and visits legislators and such, she received several threatening phone calls and text messages from an attorney with the Florida Justice Association. And they accused her of things she never did. They accused her of things she never said, and actually made some threats that put her in fear for her life or her safety. And so when this attorney speaks, the guy that's going to speak is not the one who called her. I'm not going to name the one who called her because that's a pending matter. But the guy who's going to speak, I want you to listen to what he says. And when he gets done, I want to share something with you that I sent to Senator Yarborough.
Thank you. Eric Tinsman, followed by Bobby Bowers, and then Jason Goldman. Mr. Tinsman, you're recognized.
Good afternoon. Eric Tinsman on behalf of the FJA. My grandfather was a doctor. He was a small town doctor. He was the doctor for the local high school football teams. My sister is board certified in emergency room medicine. She's a pediatrician. She runs an emergency room. I am pro-doctor, but I also believe in separation of powers. Our Supreme Court has ruled on this twice. What you are doing, respectfully, has been ruled unconstitutional twice. Okay? Our founding fathers set it up that way. The courts rule, the legislators make the laws, the governor executes. You are going against something that's already been ruled unconstitutional. There are two places where every American is equal, no matter how much money they have: at the ballot box and in front of a jury. The same people you rely on to elect you are the same people in that jury box. Every election cycle, someone comes in hungry for power and overspends. They think, I can spend money and win this election, but the people go against that money. Happens every election cycle. Just because you have the most money doesn't mean you win an election. Just because you have more money doesn't mean you get to tilt the scales of justice and put caps on pain and suffering. You rely on the people for your ballot box, you need to rely on them in a jury box to figure out what the value is when a baby is switched at birth. Happens every year. To allow the jury to decide what it's worth when the wrong leg is amputated. Happens every year. We're kind of not talking about what's really going on here. Out-of-state hedge funds, private equity from California, New York, they're the reason these doctors are so busy and overworked and committing mistakes, okay? So we're gonna rely on a cap that's gonna keep that down, or are we gonna allow the jury to decide that that radiologist should not look at 10,000 slides the day he missed that mammogram?
Mr. Tinsman, I'm gonna have to ask you to finish your comments.
I appreciate it. I'll say one more thing. I think this is an objective statement. There are three ways to deal with injured and grieving people. Our system, the best in the world. Big government bureaucracy like Europe, where the nanny state steps in and decides how much a life is worth, or Mad Max. We should keep it to this system where we trust the same ballot box and the jury box. Thank you. God bless.
Thank you, Bobby.
Okay. I happen to agree with absolutely everything he said, with the exception of what he talked about hedge funds. And the only reason I don't agree with that is because I'm not sure what point he was making. I think the point that he was making is that because doctors are so overworked, that causes them to become negligent from time to time. And that may be true. I don't know enough about what he's talking about, these hedge funds, but I made some notes on the rest of what he said. And I'm going to take this screen down because in a moment, I'm going to share another screen with you. He talked about the separation of powers. And then he talked about the two Florida Supreme Court rulings. And then he talked about the jury box and the ballot box. And then he talks about the same people that vote are the same people that make up the juries. And so that if they can trust you to vote for them, to vote for the legislators, then you should be able to trust their verdicts. And then he says that the jury should decide what the damage awards are. I agree with every bit of that. I have absolutely no complaint with that. Then he ended with talking about there are three ways to deal with the problem. One is, the nanny state taking care of it, and then the other one was Mad Max. And I think that what he was trying to say is that if our system doesn't work the way that it was designed, that the people speak through their representatives to write law that reflects the way they want to be governed. And if they don't do that, then the people revert back to the state of nature that John Locke talked about and that Jefferson talked about. So I'm going to share another screen with you at this time. Let me know when that pops up, Travis.
What's up?
This is a letter that I sent to Senator Yarborough on the 6th of January, before the legislature even went into session. Can you see my cursor at the top of the screen?
Yes.
Okay, it says Yarborough email on 06 January 24. So that shows the date that I wrote it. And this is what I said to Senator Yarborough. Our system of government was designed such that the people always have the final say in matters affecting their consent to be governed, from the ballot box to the jury box. Therefore, it is reasonable to allow the people, the jury, to decide the appropriate restitution and punishment when a doctor is found guilty of negligence. If lawmakers trust the people's judgment when electing them to office, then it is only reasonable for them to trust our judgment or our verdict when a jury finds that a doctor or nurse has been negligent. And then down towards the bottom, my closing paragraph is, in a civil suit, of course, both plaintiff and defendant have the opportunity to persuade the jury. If the jury finds that a doctor's actions amount to nothing more than human error, the data supports that the jury will compensate the victim accordingly, meaning that they won't give them a really high jury award if they recognize that it was just human error and not absolute intentional negligence. Excuse me. However, when a jury has been presented with facts that show a doctor's negligence was so egregious as to warrant a significant award against him, then the people have spoken and are sending a message that they will not tolerate that type of behavior in their community. This is how our system was designed. We should let it work. Now, you tell me that there aren't some similarities.
Just about 2 or 5, you know?
Yeah, I would say it's a little bit more than that. Now,
You got a groupie.
I'm happy if that attorney from the Florida Justice Association read my email to Senator Yarborough, because I sent it to more than him. And in fact, I read this in an earlier podcast that I did about a week ago. You know, I think it's great if he read my letter and he thought there were some valid points in it that could be used to persuade the legislature to, repeal subsection 8. What I find interesting is that just, what was it, less than a week ago, the FJA was calling Sabrina, threatening her and trying to, scare her. And now they're using the research that we've done and the letters that I've sent. They're using that. So I don't know. Who knows? Maybe coincidence struck and all the stars aligned and he just happened to come up with the same ideas, that I had. An old friend of mine that you've heard me speak of quite often, a guy named Sid Johnson, who was kind of like my mentor and my grandfather. He told me that the truth is the same where one man puts it down and another man picks it up, meaning it doesn't matter what route you take, doesn't matter what path you follow. If you're looking for the truth, you're both going to end up at the same destination. So maybe that's why me and that attorney seem to agree on all of this.
Well, that's encouraging because he found the same truth you were.
Exactly.
So that's a good one to watch.
Yeah. So I think I'm going to reach out. One of the members in our group wrote to me. Actually, she posted it in the group this morning. She was able to understand that guy's name. So now I have his name and his website. I'm actually going to write him or call him and see if he'll talk to me. Because like I say, I agree with him. I agree with everything he said. And I'd like for him to explain the hedge fund thing to me so I can understand that argument better as well. We're at the almost at the 48-minute mark. And how much time are we at, Travis?
We've gone over what the timer was for.
Okay, so we're getting close to the 1 hour mark. So I think I'm going to stop the podcast here. We still have from 48 minutes, up to this thing. We still got like another hour worth of this meeting. But I know if we make our podcast too long, people won't watch it. So I'm going to break it off here. You have any closing thoughts? You have anything you'd like to share on what we heard tonight?
Nothing I don't want to get into right now, just because it'll take time and make it longer.
Okay. Well, then I'll go ahead and get this podcast uploaded. And then tomorrow night or tomorrow sometime, we'll try to pick up at the 48-minute mark and move on from there and just keep breaking this down. And so this will be part 2. Look for part 3 tomorrow. And like we always say, we're not attorneys. We're just a couple of guys who found ourselves in the same hole, trying to find justice for the death of our mothers. And I feel blessed that I met Travis. I hope he feels the same way about me.
Certainly do.
And we're just seeking the truth and trying to share our journey with you. And about the only thing that we give advice on is go buy a book and learn something so you can make a valid argument. So everyone have a good evening. Like, subscribe, ring the bell, invite your friends, make the popcorn, all that kind of stuff. Hang on, Travis, and we'll talk for a minute after I end this.